You've heard me talk about estate planning on this program before. You've also heard me talk about buying real estate on this program before. In this video, I'm going to explain the different methods of holding title to real property and how it relates to estate planning. Hello again, this is real estate broker Daryl Williams here in Southern California. Thanks for watching this video. On this program, we talk about real estate and probate related topics. So if you're interested in that type of content, please like, share, and subscribe. Let's get started. The way you hold title when buying a home is a critical factor in the estate planning process. When you buy a home or change title to an asset, it is important to understand the impact that decision will have on you and your family. My job as a real estate professional is to explain the difference between the methods of taking title here in the state of California. Unless a real estate agent is a licensed attorney, that agent should not advise a customer on how to take title to real property. They should only explain. First, let's take a look at how title is held when you own property separately from anyone else. That's called ownership in severalty. It's a sole and separate exclusive possession of ownership of real property. A person may hold title separately under the following titles depending on the legal status of the owner: a single man, a single woman, a married man, a married woman, an unmarried man, an unmarried woman, a widower, a widow. All of these titles indicate separate ownership of real property. Another type of ownership is concurrent ownership. That's when two or more persons hold title to real property together. There are several types of concurrent ownerships, but for this video, we're going to take a look at the most common ones. Joint tenancy with the right of survivorship, Tenancy-in-Common, also known as Tenants-in-Common, community property, which is subject to probate, and community property with the right of survivorship, which is not subject to probate, and tenancy in partnership. So let's take a look at joint tenancy with the right of survivorship. I heard a probate attorney say that more than 70% of new buyers take title this way, and it is absolutely wrong for their estate planning. When one joint tenant dies, the property automatically transfers to the surviving joint tenant without an impact on the deceased person's will. No probate would be necessary. Ultimately, when the surviving, or the last, I should say, joint tenant passes away, the property will have to go through probate if no prior estate planning existed. Now, let's take a look at concurrent ownership, tenants-in-common, also known as tenancy-in-common. If you own property as a tenant-in-common and one of the co-tenant dies, that co-tenant's interest would pass to their beneficiary, even if that co-tenant were married. Also, as a co-tenant, you could transfer and or sell your interest. Now, let's take a look at concurrent ownership community property. Community property is typically reserved for married couples or registered domestic partnerships. Property acquired during marriage would be considered community property. Does that apply to all personal and real property of an individual? No. One may retain their separate property prior to marriage or during marriage if it is a gift or an inheritance. A community property owner may will their interest to their beneficiary. Now, let's take a look at community property with the right of survivorship. The major difference between community property and community property with the right of survivorship is when one of the community property co-owner passes, the property will automatically transfer to the surviving co-community property owner. Now, let's take a look at the last common co-ownership or concurrent ownership, and that is tenancy in partnership. Tenancy in partnership exists when two or more persons pool their interest, assets, and efforts together in order to form a business venture that will share in the profits as well as the losses. Are there other ways to leaving assets to loved ones? Definitely. However, the ones that I just reviewed are the common ones, and those are the ones that a lot of us will deal with when having to make a decision on how to hold title to real property. The other ways of transferring personal and real property we could address in another video. If you've gotten value from this video, please like, share, and subscribe. This video has been intended for information purposes only. It is not intended to be legal advice for any shape, form, or fashion. If you need legal advice, please consult an attorney. If you need an estate planning or probate attorney, feel free to contact me for a referral.